So when in Canada do you have the right to ask a police officer to perform a blood test to determine your level of impairment? The answer is never. According to Canadian law, the police officer has the sole discretion for determining at the roadside or in the course of the investigation what type of test is going to be administered. And as long as that test is lawfully administered and demanded of you, then the police officer's decision can't be interfered with by your decision instead to take a blood test. For example, if you think that a breath test is not reliable or a physical coordination test won't tell anything about your level of impairment due to your medical condition or injuries that you have, you don't get to choose to provide a blood sample instead. And you can't offer to the police officer that you're going to take a blood test instead of doing a breath test and have that considered to be compliance with the officer's demand. Canadian law also prohibits the circumstances and limits the circumstances in which police officers can actually get a blood sample. Blood is considered the most intrusive way of testing your sobriety. It also reveals the most personal information about you because it is your DNA, it's everything that's in your system in measurable amounts. It is the most biological core about you. And so police officers can't just demand a blood sample. They have to just have reasonable and probable grounds to believe that you've committed an offense related to impaired driving of some sort, but also that it would be impracticable to obtain a sample of your breath for analysis due to your physical condition. And they have to make sure that they know that taking the blood sample wouldn't endanger your health or put you in any type of medical jeopardy. So they need to consult with a qualified medical practitioner before demanding a blood sample. For all of these reasons, police don't often get blood samples from individuals who are able to walk and talk and provide breath samples or participate in physical sobriety testing, even though there might be concerns about the reliability of those tests. It's on you to demonstrate after the fact that there was some unreliability issue by raising what is known as evidence to the contrary. And that's not even just saying I had 2 beers, but in fact showing that the test was not administered correctly or that there was a flaw in the procedure or a malfunction in the instrument that led to unreliable results. So you don't have a lot of choice when it comes to sobriety testing and impaired driving in Canada. If an officer demands that you participate in a type of test, you should pretty much assume that you're obligated to do it and participate as the officer directs you to do so.